For decades, English family law operated on a burden of proof. To legally terminate a marriage, the system required specific evidence of spousal misconduct. Practitioners had to document one of 5 specific facts, such as adultery, unreasonable behavior, or desertion, to satisfy the court. With the Divorce, Dissolution, and Separation Act 2020, these adversarial requirements were redacted from the law. The legislation established one universal ground for severing a marriage or civil partnership: the irretrievable breakdown of the relationship. This change redirected the daily focus of the family practitioner. The legal challenge is no longer gathering evidence of blame, but maintaining absolute precision in following the schedules of the Family Procedure Rules 2010. Before the clock starts, the Children and Families Act 2014 requires applicants to attend a Mediation Information and Assessment Meeting, or MIAM. Aside from cases involving documented domestic abuse, this meeting is the mandatory gatekeeper. The legal timeline cannot officially begin without it. Once that requirement is met, the practitioner manages the case toward the central procedural milestone, the conditional order. Because the court no longer adjudicates the reasons for a split, navigating the FPR timeline with chronological accuracy is the only mechanism for a successful severance. Modern proceedings are managed through the HMCTS digital portal, providing a paperless link between practitioners and the court system. The terminology has also shifted. The party initiating the proceedings is now the applicant, replacing the historical term petitioner. Day 0 is the date the application, Form D8, is issued by the court. This must be accompanied by the marriage certificate and fee. However, Section 3 of the Matrimonial Causes Act 1973 and Section 41 for civil partnerships imposes an absolute barrier at the 1-year mark. No application for divorce or dissolution can be legally presented to the court before the first anniversary of the union. This rule prevents legal filings during the immediate first year of a marriage or civil partnership. A party can rely on events that took place during those first 12 months, but the actual filing must wait until the year has elapsed. A practitioner's first duty is to verify the exact date of the marriage certificate to confirm eligibility. Calculating this anniversary is the jurisdictional prerequisite. Without it, the legal timeline cannot begin. Once issued, the case enters a mandatory 20-week waiting period. This acts as a statutory cooling-off phase. No conditional order application can move forward until this window expires. At this threshold, the procedure follows one of 2 distinct tracks based on the initial filing. On a sole application track, the passage of time is only part of the requirement. The applicant must provide the court with evidence that the divorce documentation was served on the respondent. Under Part 6 of the Family Procedure Rules, this involves filing an acknowledgement of service, a certificate of service, or an order for deemed service. Modern rules also allow for effective service via email, provided the practitioner follows the specific digital service protocols. Alternatively, the joint application track allows both parties to move forward together. In this case, reaching the 20-week mark requires both parties to actively apply for the conditional order. When the first party initiates the application, it opens a 14-day window for the other party to respond. The second applicant must complete their portion of the application within this 2-week period. If the second party fails to act, the joint process stalls. To prevent indefinite delay, the rules include a built-in procedural switch. The first applicant can unilaterally convert the process into a sole application to progress the timeline. The 20-week mark is an active procedural checkpoint. Here, the case only advances once the applicant provides evidence of service or joint compliance. This creates a problem for clients whose marriage has collapsed but who have not yet reached the 1-year anniversary. In these cases, a practitioner can use Section 17 of the Matrimonial Causes Act to apply for judicial separation. This order legally ends the spouse's obligation to live together. It also allows the court to make broad financial and property adjustment orders, providing many of the remedies available in a divorce. However, judicial separation does not dissolve the legal union itself. Because the parties remain legally married, they are not permitted to remarry. There is also a specific impact on inheritance. Under Section 18, neither spouse can succeed to property if the other dies intestate. Judicial separation is a tactical option for those facing the 1-year bar, or for clients who have religious objections to a formal divorce. Once the gate is passed and service is proved, the court pronounces the conditional order. This starts the final mandatory wait, 6 weeks and 1 day. After this period, the applicant has a 12-month window to apply for the final order. If the applicant does not act within that year, the procedural advantage shifts to the other side. The respondent can then apply for the final order, though they must wait an additional 3 months to do so. For sole applications, respondents have specific financial protections under Section 10 of the Act. A respondent can ask the court to delay the final order until fair and reasonable financial arrangements are resolved. Once the order is granted, it results in the absolute legal termination of the marriage or civil partnership. The old system of proving fault has been replaced by a system of precise statutory deadlines. Successful family law practice now requires exact navigation of the FPR timeline, maintaining chronological discipline from day 0 to the final order.